So battery is where you might have had the intent, in fact, you had the intent to cause bodily injury onto another person. It does not necessarily have to mean that that individual sustained an injury. And battery can vary from a misdemeanor battery to substantial battery that carries with it felony charges. It really just depends on the situation and the significant injuries or the significance of the injuries to the other individual. So the difference between a misdemeanor battery and a felony battery would be the significance of how injured the other individual would be. And the penalties can vary so widely. With a misdemeanor battery, you're facing up to 9 months incarceration, $10,000 fine, or both. Whereas in a felony, it can range anywhere between 3 years imprisonment to 10 years, depending on what you're charged with. So the main thing that the prosecutor would look at when they're evaluating a case to see if this is going to be a misdemeanor charge for you or if it's going to be a felony battery would be the extent of the injury to the other individual. And so what I mean by that is that let's say you have a simple battery where no one actually got hurt, but you had the intent to cause bodily injury to that other individual. Then that would be a misdemeanor charge where you're facing somewhere between 9 months of incarceration to a $10,000 fine or both. However, you may then have a situation where you got into a huge bar fight, right? And you maybe broke the other guy's nose, something like that. Now you're looking at potentially substantial battery charges that carry with it a felony conviction. Now, those types of felony convictions can carry with them different penalties in terms of the number of years that you would be incarcerated and what the fines would be. I will put down the different classes of those on my website so that you can go to that and you can reference the resources for yourself as in terms of the penalties. That's a really good question, and this comes up pretty frequently. So the misunderstanding or the misconception about this question is that if an individual or the victim wants to drop the charges, I'm scot-free, right? Mm-hmm. But that is not always correct. In fact, the state or the prosecutors are actually the people who make the decision as to whether or not you are charged with the crime. So the victim then, their opinion matters, but it's not the it's not the entire reason why the state would continue to charge you with the crime. So victim recantation, or when a victim changes their mind, can be significant in a number of ways. It can help you at a jury trial, if that's the direction that we decide to go. It can also help you if you decided that you wanted to take a plea for it. However, it does not necessarily mean that the state is going to drop their charges. They can still say that we can still prove the charges even without the victim's statement. And if that's the case, then you're still facing your criminal charges and you still have to come up with a defense, or your attorney would help to negotiate a lesser offense for you and penalty.